that people misunderstand about estate planning. A lot of things they misunderstand about their own documents that they have and what those documents actually do for them. So it's important to know one way or the other what your plan does for you and whether or not it actually meets your estate planning goals. On top of estate planning myths, there's a lot of elder law myths, a lot of long-term care nursing home myths that people misunderstand when it comes to protecting things and planning for those expenses or trying to make sure that their loved ones' assets aren't eaten up entirely by their expenses. So there are a lot of things that people think sound like the right path forward, but unfortunately either don't accomplish the goals they're trying to accomplish or actually cause issues. So it's really, really important to know or have someone who knows about this type of planning help guide you along that path. So hopefully we'll be able to run through any questions any of you guys have, and we will run through the materials that we're handing out as well. Or so if you registered via Zoom, you can receive this handout after the presentation is over today. You'll be getting an email. This is a perfect topic for Halloween because it's things that might give you a little bit of a scare if you realize that you didn't quite understand the documents you were using in your plan. So welcome everybody again. I'm Justin Randall. I'm an attorney with Hooper Law Office. As I mentioned a second ago, we are going to be talking about sort of estate planning myths and spooky stories with estate planning. Things that can go wrong if you don't quite understand what your planning does for you or if it's not set up properly. So we're going to be covering kind of a broad range of different myths, if you will, from just general estate planning myths to long-term care planning myths and things you might have heard from other people that sound like good advice, but are either they read it on the internet somewhere, which is something you always want to be careful about, or somebody told them just incorrectly within their own family. So if you registered for this webinar via Zoom, you will be getting a handout from us. It's our top 9 estate planning myths. So it kind of walks you through those myths, but also tells you exactly, what the actual fact, what would actually happen if in that exact situation. This is an interactive webinar, so if you have questions, you can certainly submit them to the Q&A box if you're participating via Zoom. And another thing you'll be getting from us after this webinar is our evaluation form. So that can do a couple of things. One, the evaluations are just very helpful for us. They let us know if there's any topics you'd like to hear or if there's anything we could do to improve. We've been doing seminars for a long time, but webinars are still something that we're fully accepting feedback for and how we can improve that. The other thing those evaluation forms do is if you hear anything today that raises any concerns for you or you would like to come in and talk to us, you can fill out that evaluation form and select that you would like us to reach out to you for an initial consultation to set something up for that. They are free 2-hour initial consultations. They don't cost you anything to come in and talk to us. So if anything today is concerning to you, please fill that out, and that's what allows us to reach out to you. Otherwise we won't reach out to you if you don't select that you would like us to. I guess to start, I'm going to start with probably one of the biggest myths that or misconceptions that a lot of people have with estate planning. The first is, okay, so I have a will drawn up. So that means I'm not going to go through probate. My estate will avoid probate entirely. And the issue with that is that wills are not, they do not avoid probate. Wills are specifically a list of instructions to a probate court of how you would want things divvied up, who you want in charge of the estate after you're gone, where you want certain items to go, things like that. So that can cause a couple of problems for people who misunderstand that. One is if you don't want to go through probate, having a will as your main document, it's not the right tool for you. It doesn't do what you want it to accomplish. The other issue that people often run into is they have a will and they have all these special provisions in there for their children and their maybe their grandkids. They have certain protections for them in those wills, but then they have all of their assets avoid probate with beneficiary designations. So like a transfer on death or a payable on death account, or a designation on an account. So those are things that don't go through probate, they pay out or transfer directly to the individual that they've listed. That means, though, that if you have all these special provisions in your will, that you don't, those beneficiary designations are going to supersede them, they're going to avoid that, and you're not going to have the planning in place that you thought you did. So if you have a will, it's very important to know that it only controls assets that go through probate. So if it's your intention to use it, you want to actually purposefully send certain items through the probate process to make sure that at least something is there to pay bills and to follow the provisions that you put in those wills. One of the other myths is that it's the size of your estate that's the most important factor of, what type of planning you have, or what type of documents you use, or whether you want to do any planning at all, right? Now, and that's a myth. I mean, it's really not the size of the estate that matters the most. I mean, it certainly impacts maybe what type of planning you do. If you have taxable estate concerns, you're going to have different planning than somebody who doesn't have a taxable estate. Or even somebody who has a deficit estate might have some deficit estate is when you owe more money than you're worth. You're going to have different planning than somebody who does have a taxable estate. But that's not the most important factor. The most important factor is what is your goal first and foremost. Do you want to go through probate? Do you want to absolutely avoid it? That's going to be a really big determining factor of what type of plan you use. And the other thing is what are your family situations like? Do you have any particular family members that you have concerns that you want to help address through your estate planning? Is there any substance abuse issues in your family, or children with special needs? I mean, anything like that. Those are going to be much more important to the provisions in your estate plan, maybe what types of documents you include in your estate plan versus how much money you have. That's certainly a factor, but it is by no means the most important factor. So another myth is that estates can avoid probate with a pour-over will. So a pour-over will is a document that is often included along with revocable trust-based planning or trust-based planning in general. So trusts, as opposed to wills, are usually what someone will use if you don't want to go through probate, but you still want to have sort of that plan like a will, where it lists the, who's in charge of the estate after you're gone, where you want assets to go, how you want things divided up. So they function like that, except they don't go through probate. But what a pour-over will does in those situations is if something is not properly titled in the name of that trust, it will redirect the assets back to that trust. The common misconception, though, is that, I have this pour-over will, which means I'm still going to avoid probate no matter what. Well, because a pour-over will is a will, it still only controls the assets that happen to go through probate. So you may have this pour-over will, and you may have certain assets that were not titled properly in your trust, maybe just still in your own individual name. But if those assets still have beneficiary designations on them and still avoid probate, that pour-over will is not going to control those assets, and it will likely not direct it back to the terms of the trust. So, and in general, though, just understand too that because it's a will, that pour-over will is not going to have any authority over things outside of probate. So just because you have a pour-over will does not mean you will avoid probate. It doesn't mean that something going through the probate process is otherwise suddenly not going to go through that process. If that's where that asset ended up, that pour-over will still help you direct it back to the trust, but it will not allow you to avoid probate with that asset. So just a reminder, if any of this is confusing, please ask away questions, or if you have personal questions you'd like to ask. In general, there's an unfortunate misconception with people who have children with special needs that the only way to preserve their benefits that they may be entitled to through certain programs, like government-based programs, the only way to maintain their access to that is to disinherit them, because a lot of these programs are tied to how much money they're allowed to have and how much money they do have. So they think by leaving all these assets to them, they will lose their benefits. And that's, if you just left it to that individual outright in their own name, that would likely happen. But it's unfortunate that a lot of people assume that you have to leave nothing to them, that you have to disinherit them entirely in order for them to qualify, maintain those qualifications for those benefits. There's a lot of planning you can actually do through a will or a trust or your estate plan, whatever document you're using, where you can set up certain planning for them to still leave assets for their benefit. Often having somebody inherit in what's known as a supplemental or special needs trust is a really good tool to use to still leave assets for their support. But that special needs trust is set up in such a way that it can't be used for the same things as their benefits. It can't supplant their benefits in any way. It can't supersede them. It is used for different things, and it cannot be used for the same purposes of their benefits. So that what that does is it does not disqualify them from their assistance that they're currently receiving. So, if you want to leave assets to a child with special needs, whether it's your own child or a family member or just a family friend, whoever it is, you can set up certain provisions in your planning to make sure that they're taken care of, that their benefits are not taken away from them because you left them any sum of money. But it is really important that it's done correctly. So if that's something you want to do, absolutely talk with an estate planning attorney. Make sure that you're doing it the right way. Another myth that commonly comes up is, well, I have this trust, right? So now that I have this trust, I don't really need to title anything in the name of it. It's not really that important. It'll get there eventually. So that is absolutely not true. A trust only controls the assets that it owns, that it's titled or that are titled in its name, or are otherwise beneficiary designated to it after you pass away. So things like retirement accounts, for example. That is essential to making sure that those assets are controlled by that trust. Unfortunately, a lot of attorneys, when they set up trusts, they don't go through and fund those trusts for their client. I mean, that's something we absolutely do for our own clients. And it's just so essential to making sure that the plan functions the way it's intended. I can design the best trust in the world, but if none of the assets you own are controlled by the terms of that trust, it was essentially a worthless piece of paper for you. So it's absolutely essential that your trust is properly funded, the same way that it's essential that you have certain assets go through probate if you have a will and you intend to use it. It's kind of like using the right tool in the toolbox. You wouldn't take out a hammer to screw in a screw, right? You want to use the right tool, and you want to actually use it when you've paid for it. Another common estate planning myth is that trusts are only for the wealthy. Sort of like, the earlier myth of it, the most important thing is how much money you have. Trusts are not only for the wealthy. A lot of people have trusts because of what their intention for their estate is. So I mentioned that wills only control assets that go through probate. And trusts are a tool that people use to still provide similar planning to a will, similar central kind of division of the estate, who's in charge, all of that, the same control that a will provides for an estate, but trusts avoid probate. So if you want that planning in place that a will can provide for you, but you don't want your assets to go through probate, if that's your primary concern, a trust is a good option. It's something to look into. So this can be for people who are middle class, who are upper middle class. It can be people who are incredibly wealthy can have trusts, but it can be a broad range of people who utilize trusts. It's less about how much money you have and more about what you intend to have happen after you're gone. If probate is something you intend to use, then a will is the better tool for you. But if you absolutely don't want to go through probate, a trust is the better option, because that's what they're designed to do primarily, a revocable trust primarily. And then another estate planning myth that we often run into is that the issue that we run into with taxable estates, for example, people think, oh, well, life insurance proceeds do not get taxed. And it's true that they don't get, they're not taxable income to somebody, but they are counted as someone's estate. So if you do have estate tax concerns, don't assume that life insurance won't be subject to that estate tax. You could lose upwards of 40% of that, those proceeds as part of that estate tax. One of the scary situations that comes up when things are not set up properly. So I'll give you two examples. One is whether you have, or if you have a will, for example, and you have all of your assets beneficiary designated. So let's say in that will, you have a child with special needs and you set up a special needs trust for them in that will. But you have them directly as the beneficiary without properly aligning it with your planning. You have just that child as the beneficiary, and all of those assets go to that child. The common problem with that is that, well, now you've just put all of that money in their name. So you had the best special needs trust in the world for them. It was designed to not have them lose their benefits, but because all of those assets went directly to them and your planning was not properly coordinated, they may lose their benefits, and that was not your intention, even though you had this really good planning in place for them. So it really goes to show you what can go wrong if you're not being very intentional about how you set this up. And no one is saying you have to do this on your own. I mean, that's why people like us have jobs, right? We're here to help you with that. With trusts, for example, a common planning mechanism that we use is to try to protect certain assets for people, either from themselves or from other people. So things like if they were going to get sued or divorced or were in a high liability career, and we're more likely to get sued than somebody else. There are things you can do to protect those assets for people through an estate plan, whether that's a will or a trust. But again, if you just outright beneficiary designate everything to those individuals, that could create a problem as well. Another thing is when you are sort of protecting people from unforeseen things. So maybe you put all of this planning in place to say, well, nobody I know in my family currently has a substance abuse issue or is currently irresponsible, and so I don't think anything's going to go wrong, but I'm going to make sure that just in case that happens, there are protection mechanisms in place to stop them from harming themselves with any money I give them. That is another situation that often will put in place. But if something goes wrong with the funding of the trust, or something doesn't properly go through probate, if you're using a will, the issue you run into is that they'll still beneficiary designate it directly to those people. And when that happens, if that money just goes to somebody with a substance abuse issue, there's no stopping them from using it. If it's just within their own control, there are a lot of situations where this comes up, and that is not what you want to happen if your entire goal was to stop them from using it for their substance abuse issues. So you can put someone else in charge of the money you leave them, but it has to be subject to your estate plan. You cannot leave it directly to that individual with a beneficiary designation or a transfer on death, because once it's in their name and they're the owner of it, they're in control of it. Another type of planning we do often is long-term care planning, looking at things from a nursing home perspective and trying not to have everything subject to spend down necessarily. So there are a couple pretty big myths that people, or in just common questions we get about this type of planning, where this can be a little more risky, and things can go really wrong really quickly if you don't know what you're doing with this and you accidentally make the wrong decision. So first and foremost, the biggest thing people always talk about, and I'll talk about it from the perspective of your home, because it's the biggest asset that people are generally concerned about, but this can be any financial asset. So people say, well, I don't want my home to be subject to my long-term care planning expenses. I don't want it to be eaten up by my care costs. How do I protect my home? Do I just put it in the kid's name? That is the most common question I would say I get regarding long-term care planning. And you absolutely, that is the worst thing you can do. You do not want to just put the home in the kid's name. There are way better ways to deal with that concern. A couple of things that often go wrong when that happens. First and foremost, long-term care planning, a lot of it is about maintaining as much control over your care, over your lifestyle, over the quality of life that you want as possible. And the number one way to lose control over something is to just put it in someone else's name. You put it in your kid's name, that's where you hear these scary stories about, well, the greedy son started charging mom rent or evicted mom after she put the home in his name just to protect it from her nursing home expenses. So it's not something you want to have happen if your entire goal was to protect it to begin with. That's just another way of losing it then. So even if you have the best kids in the world and they're not going to evict you and they're not going to charge you rent, there are other things that still often go wrong with the home in particular. The biggest is that once you put something in someone else's name, that person's liabilities also happen to what they own. So, if you were ever sued as the owner of your home, or you ever filed for bankruptcy as the owner of your residence, you have some protections under the law to stop somebody from going in and just and you suddenly being homeless because of it. There are certain protections that you have as the owner and resident of that home. However, once you put it into the ownership of your kids, if something happens to them and they get sued, or they get divorced or file for bankruptcy, any of the things that can happen to somebody, those now also happen to your home as well. And most likely the home you've put into their name is not their primary residence, so they don't have those same protections that you would have under the law. It would be looked at no differently than if they had a vacation, like a lake house up north or a cabin up north. It would be a second property. So if they filed for bankruptcy, it's entirely possible that your home would have to be sold to help them out. So it's just something that you want to be very careful of and not, open up your assets to new liabilities just to protect it from nursing home expenses. Another really big one is putting the assets, especially assets with capital gains, so like real estate, things like that, into the kid's name. It creates a lot of potential tax issues down the road. The biggest, being, when you pass away, your home gets the cost basis in it gets adjusted to fair market value. So what that means is that after you pass away, if your kids then turn around and sell the home, they may not have to pay any capital gains taxes on it at all because it looks like there was no gain to the IRS. However, when you transfer something over to somebody during your lifetime and don't sell it to them, that cost basis gets transferred over as well. So if you bought your home back in the 60s and it was worth $50,000 at that time, but today it's worth $250,000, well, that cost basis is going to be roughly around that $50,000. So that transfer over to the kids, then once they sell it at that point, even after you've passed away, because you didn't own it when you passed away, they did, they will have to pay capital gains tax on the difference between what they sold it for and what the cost basis was. Barring a few exceptions, like if it was their primary residence, then you get an exclusion from that. But most of the time, that's not the case. So it's just something you want to be careful about. Giving all your assets to your kids, it creates a problem for the 5-year look back for Medicaid primarily, but it also opens it up to a lot of other issues as well. So this is a really, the next myth I'm going to tell you is a really common question as well. People think it's a way to get around the 5-year look back period. You're not creating a divestment when you do this. That's what people think. The gift tax exclusion that you've all probably heard about, the roughly $15,000, or excuse me, exactly $15,000 per person per year that you're allowed to give away without filing a gift tax return. People think that's a way around the 5-year look back period, that, if I just continually give, I don't go over that amount every year for each kid, I can get all of my assets to my kids without worrying about any sort of Medicaid, 5-year look back problem. Unfortunately, that's not the case. So Medicaid says you can give away $0 per year. You can't give away anything without it being subject to the 5-year look back period. Where that confusion comes in is people think, well, because the IRS follows that rule, every government program follows that rule, and they don't play nicely together. They don't follow each other's rules. They each have their own rules for each program. So when you just don't have to file a gift tax return if you're gifting under that amount, but any amount that you gift for long-term care purposes, if you're giving it for any reason, really, you have to then show that it either you met some sort of exception to the 5-year look back rule, which most things don't, or you actually paid for a good or a service with that. So you have to either show that it was in exchange for something for fair market value, or it met some sort of exclusion. Most of the time, people can't prove either of those things when they're gifting things away. So any amount that you gift, if you're doing that $15,000 per person per year, and you think you will need long-term care at some point, and you don't have enough other assets to pay for that care out of pocket, that will not get it protected for you. It's, you may make it out the 5 years, but if you don't, it's going to be counted against you. Speaking about trust, we've talked a lot about revocable trusts today as well. People think by placing their assets in a revocable trust, they're also protecting it from their long-term care expenses. That a revocable trust does, gets things out of the eyes of Medicaid. They can't get at it. Unfortunately, anything in a revocable trust for Medicaid purposes is still a countable asset for you. So just because you have a revocable trust in place does not mean that your assets are going to be protected for long-term care purposes. Maybe you don't have a concern about paying for your own care. Maybe you have enough income in retirement or enough assets otherwise that you are otherwise covered. And in that case, that's okay. But if you think that a revocable trust is going to stop Medicaid from counting it against you, it's unfortunately incorrect. There are other types of trusts that you can use, different types of irrevocable trusts that are a little different, that we do often use for Medicaid planning and do often use to stop something from being countable as part of what you're allowed to keep for Medicaid. But one of the big differences between the two things is often with revocable trusts, you're often your own trustee. You're often in complete control of everything. Your day-to-day life is really no different than if you just owned it in your own name, right? That's too much control for Medicaid. They would look at that and say, well, otherwise it's essentially just yours. You can use it whatever you want. So just because it's in this entity or that entity does not necessarily protect it from those expenses or from being accounted against you. With an irrevocable trust, you can't be your own trustee for Medicaid purposes. You don't want to necessarily be receiving income from it. You don't want you to be able to take everything back right away. It's the level of control you would have is a lot less over an irrevocable trust. Now, we often still put the children in charge, as long as that you trust them and all of that, but it's not the same level of control that you would have over a revocable trust, and they just don't protect against it. And they use, prior to 2014, they used to protect against estate recovery, which is when Medicaid can come in to the estate as a creditor and take back what they paid. However, any trust set up after 2014, it does not protect against estate recovery anymore. And quite frankly, I still wouldn't even want to rely too much on them understanding that for the pre-2014 trusts. I'm a little more cautious when it comes to that kind of thing. So it's definitely something, long-term care expenses are definitely something that people are often worried about. It's very expensive, but the planning they try to do on their own is often causes more issues than it's worth, or in the end doesn't protect anything. So the gifting everything to the kids is the worst, just because you're not really protecting it all that much. I mean, you might get it out of your name for long-term care purposes, but now you're just opening it up to a whole lot of other issues. Your kids' liabilities, or the complete loss of control with the home where somebody can evict you or charge you rent. the reason an irrevocable trust is a little better than, or is a lot better, I should say, than just putting the home in the kid's name is you're often granted what's called an occupancy right. So in exchange for me paying the property taxes and the utility bills and all of that, my trustee can't evict me. They can't charge me additional rent or anything like that. So you get a lot more protection for yourself with an irrevocable trust over gifting it to the kids directly. Now, hopefully your kids wouldn't do that to you, but it is Halloween almost, and that is a scary story. So I'll leave you with that scary story. But so if anybody has any questions that you didn't feel comfortable asking here today, certainly, again, fill out those evaluation forms. Even if you don't want an initial consult, if you just fill it out and don't check anything, put your information down about us reaching out to you, we won't reach out to you. It's still just helpful feedback. But please, if you do want us to reach out to you, fill those out. We'll reach out to you once we receive them, and we'll set something up. If anybody's interested in our upcoming webinars, we're going to be talking about, is your family protected, and all of the different ways that you can protect your beneficiaries from themselves and from others. So that'll be our webinar coming up next week. Next week, we are doing it a little later than usual. We're doing it starting at 6 p.m. actually. So still on Wednesday, but at 6 p.m. So if that's something that interests you, please sign up for that. You can go to estateplanninglive.com and or sign up for that. So thank you everyone for joining me today. I'm at 12:30, so I will leave you guys to enjoy the rest of your day. But thank you so much, and